I think we're fighting about labels, and you got to the point, but you keep resisting it, okay? The court below did not use our Brigham City standard. It used a reasonable suspicion standard. I'm quoting from itself, from the decision below. Objective, specific, and articulable facts from which an experienced officer would suspect that a citizen is in need. Reasonable suspicion, as we've defined it, means a particularized and objective basis for suspecting the particular person stopped of criminal activity. So they use a standard akin to reasonable suspicion.
Yes, Justice Sotomayor.
So what you're saying is whatever standard we announce, we should vacate and remand to go back. And the question becomes, how is Brigham City different than probable cause other than in its objective? I got two quotes, one quote from two of our cases that says, probable cause, quote, is a reasonable ground for belief of guilt. Our Brigham standard says, we're not talking about guilt here. Our Brigham standard says, objectively reasonable basis for believing, that's a reasonable ground, that an occupant is seriously injured or eminently threatened with injury. I don't know, Justice Kagan was right. This is, in my mind, simple. Apply the right standard and tell us what the objective facts were. Correct?
Yes, Your Honor, and certainly
for believing that the occupant was seriously injured or eminently threatened with such injury.
Yes, Your Honor, I would just say that that formulation in Brigham City did generate a bit of confusion in the lower courts, even though we submit that it is consistent with and really resonates with probable cause.
Well, it doesn't resonate with reasonable suspicion.
It does not, and we would be entitled to a remand on that ground. But I want to make sure I get to Justice Barrett's question.